there's another situation that pops up too, again, with the green card option that I want to talk about. And unfortunately, we're getting a lot of this, is widower cases. Widower is, a person whose spouse passed away. And they have an exception that says, listen, like if you had an I-130 adjustment case pending, or you just didn't even have a case pending, you're both overseas, and your U.S. citizen spouse dies, the foreign spouse can still get a green card as long as they don't remarry and request it within 2 years. If you have an I-130 pending, it automatically converts what's called an I-360 widower case. Or if you don't, you submit an I-360. Many times, if you're overseas, you send it directly to the embassy. Or if you're in the United States, you submit it there with your adjustment of status application. So people have to be prepared. This widower case is an interesting thing that exists. It gives you options. It's just you got to act fast. I know in a period of mourning after someone passes, you're not really the mindset, but you have a 2-year time frame to get it started. So that's to really give you the ability to come to the United States and have a green card. It's relatively straightforward, unless every case has its own nuances. For the most part, it's not the most complex thing, other than just you got to go and think about something that's really emotional and get paperwork and death certificates and all this kind of stuff. But it's doable. So it's something I wanted people to be aware of as well, of these various options. If you're interested in learning more, just email us at info@jqqlaw.com. Let me know if you have comments about that, Anya, or
just two little things. Just two little
Please.
things. First thing is that it's gonna work only if you are married to U.S. citizen, not the green card holder. First thing to be aware of, right? And the second thing is that you have to be actually married. You have to be in a valid official marriage.
Exactly.
Yes, we talked with John recently about the issue. What happens if a couple, they were not married but they live in a state that recognizes common law marriage? This is a very interesting topic. Probably, I think it still has some room for arguments in this situation.
Yeah.
But if you find yourself in this position that you were not married but you lived in a common law marriage with a U.S. citizen, maybe there's still something that the immigration attorney can do for you.
Yeah, that's such an interesting thing you mentioned. We were talking with a colleague from New Jersey, and states like California and New Jersey do not recognize common law marriages. And the old thing was, if you're living with someone for an extended period of time, essentially they'll consider that being married. But California does not recognize that. Some states do. You could potentially, if you're living in a state that does, or maybe in another country that does in some way, you could argue that although we didn't get a marriage certificate, we are recognized by our home country laws or home state laws as being married. And that's an argument to make. It's going to get tougher, and you might need extra legal work for that. But we unfortunately have a lot of people who were together for 10 years, even have kids together, multiple kids. They just never did the act of getting married for some reason. And then something like this happens, and they're out of luck many times. So you should definitely look into getting married. Don't put it off. It's simple enough in the United States to get married. Getting married overseas has some headaches, but here is just show up at the courthouse a lot of times and you're done. So that's something I'm glad you mentioned that, because we do run into that issue frequently enough.